Welcome to Wall Street versus Main Street, a different take on the investment show with our host, Dax White. Dax White is the managing partner of the White Law Group, a national securities fraud, securities arbitration, and investor protection law firm with offices in Chicago, Illinois, and Vero Beach, Florida. The White Law Group has represented hundreds of investors in FINRA arbitration claims against their brokerage firms, and throughout this show, Mr. White will shine a light on some of the tricks of the brokerage industry, while also providing valuable information for investors on how to successfully navigate the investor-financial advisor relationship.
Welcome, everyone. You're listening to Wall Street versus Main Street. I'm your host, Dax White. As we mentioned in the lead-in, I am not an investment professional. I am a securities attorney that represents investors in claims against their brokerage firm. So the objective of this show is not to provide investment advice and say, hey, buy this, sell that, or anything like that. Instead, what we're attempting to do through the show is to even the playing field a bit between the brokerage industry and investors, providing some of the information that I've picked up through the course of my practice, things that I think that I wish more investors knew, because then they wouldn't need me. And each week we sort of tackle various topics and provide that information and try to shine some of the light on the tricks that the brokerage industry uses to sell products and get paid commissions, etc. So the topic we're going to talk about today is just the arbitration process in general, because I feel like a lot of people are either unaware that they have the possibility of bringing a claim or are think it's too daunting to go through and just don't want to do it. So I thought I'd break it down. The reason we're talking about FINRA arbitration rather than court is because when you established your brokerage relationship at the very beginning in your first documentation that you're signing with the brokerage firm, somewhere buried in the fine print of that document is an agreement that said something to the effect of, if you have a dispute with us, you agree to waive your right to sue us in court and to instead sue us through arbitration. It used to be called NASD. Now it's called FINRA. So that's where all claims involving brokerage firms that are, U.S.-based, FINRA-registered broker-dealers, that's where all these claims are heard. And so there's certain things that make FINRA arbitration different than court that would be important for someone to know who's contemplating, like, do I really want to do this? Because I watch courtroom dramas and I'm afraid to be deposed, or I'm just scared to do it. Like, what are my obligations? How much will be involved for me? And because most of our clients, it's the first time they've ever contemplated suing anyone, so they're just skittish about the process, concerned about what's going to be involved for them. So that's what we're going to tackle. Again, it's FINRA, not court. And there are some significant differences. The biggest differences have to do with how quickly the process takes, how expensive it is, and the obligations of the person who's bringing the dispute. Because in court, things can take years, depending on the judge's docket. There's depositions, there's discovery obligations, there's a lot more costs that are involved in FINRA. So that's to the benefit of the investor. Is that it is less expensive, and it doesn't take quite as long. FINRA arbitrations generally take, we tell clients, between 12 to 15 months, and that has to do with just sort of the scheduling process. You really couldn't do it faster. Some cases do end up taking a little bit longer, but it's not like court where you can have things just drag on and appeal and this and that. FINRA arbitrations usually are in that range. And it has to do with, again, how the scheduling order is laid out. Typically, you'll file your complaint. We call it a statement of claim. You'll file it through the FINRA office in New York, and then they'll serve the brokerage firm. And the brokerage firm, once served, is going to have 45 days to respond. After that, the next step in the process is going to be the ranking of arbitrators, where you select the 3 arbitrators that are going to hear your dispute. And once you have those arbitrators selected, FINRA is going to schedule what they call an initial pre-hearing conference, which is basically just a scheduling conference where you lay out all of the discovery deadlines and when's the hearing and all of that stuff. And arbitrators are instructed by FINRA to make best efforts to schedule from that initial pre-hearing conference, which again is probably between 3 and 6 months from when you filed. They're instructed to try to schedule the hearing within 9 months. So that's where the 12 to 15 months comes from, is because arbitrators are told, make your best efforts unless there's an extenuating circumstance with one of the parties' calendars or what have you, to try to schedule it within 9 months of that conference call, that initial pre-hearing conference. So that's typically why it will take that long. And frankly, again, it couldn't really be done quicker because in the interim, there's going to be a lot going on, usually by the lawyers, assuming the parties have both hired a lawyer that requires that you can't do it faster. You're going to issue a discovery request that says, here's all the documents that we want. They're going to issue one saying, here's what we would like. And invariably, as we lawyers like to do, you're going to fight about it, and there's going to be motions. And so those things take time. And so that's typically why you're going to have a hearing that's 9 months from that scheduling order, because it's by the time you do all those things, it just goes by quickly, at least from my perspective, as we're working through all these cases. By the time you get all that stuff done, it's time to go try the case, but it's usually about 9 months after that process started. So that's where the 12 to 15 months comes from. I know for parties that seems like a long time, but again, in comparison to court, that's actually very quick. And again, it goes by pretty quickly. In terms of what's involved for clients, this goes back to the difference between arbitration and court. Unlike court, where parties are deposed, where you actually have to sit in a room and have the opposing lawyer ask you a ton of questions, in FINRA, that is very uncommon. It is generally prohibited unless there's some extenuating circumstances, including the possible death of a witness. So if that person's not going to be able to attend a hearing, one of the parties can move to have them deposed so that you can preserve their testimony. What would they have said at a hearing? But short of a very extenuating circumstance like that, generally there is no deposition. So we tell our clients it's very unlikely that you'll have to do a deposition. The only time that you would have to be deposed or asked questions would be at a hearing under oath at that point. But most cases settle. So for the vast majority of our clients, that's not something that they have to worry about, but certainly something they have to be prepared for. I mean, you obviously wouldn't want to bring a claim hoping that you're not going to be deposed if you're not willing to be deposed, if you're not willing to sit down and under oath answer questions. Many clients, again, don't have to deal with that, but if it happens, it's going to be at a hearing. As I mentioned, most cases, I was skipping ahead a bit because we were talking about client obligations. The big obligation has to do with just the documents. The majority of these cases have to do with suitability, representations regarding particular investments, breach of fiduciary duty with respect to recommendations, but they all generally relate to who are you as an investor and was this recommendation appropriate for you? And with that comes certain documents that are going to be discoverable in virtually every case, because in order to do that analysis, there's documents you're going to need. You're going to need brokerage statements from the brokerage firm you're suing. You're going to need brokerage statements for other firms, because that's going to speak to your investment history and your willingness to take risk, at least in your other accounts. You're going to need tax returns, because that's going to talk about your investment history, your income. The components that go into suitability are generally income, net worth, investment objective, investment experience, and age. So, if those are the components of, is an investment suitable, the only way to really determine that is to fill in all those gaps. And so really the documents are the things that both sides would need to figure out who you are as an investor. And so that's the primary obligation for someone who would bring a FINRA arbitration, is obviously you're going to have to get those documents put together. And if you're not willing to do that, then you're not willing to go forward with the FINRA arbitration, because if you don't produce documents, I can tell you that what you're going to end up with is a discovery order from an arbitration panel that says that you have to do it. And if you don't do it, they're going to take sanctions up to and including dismissing your case. So, I mean, ultimately, you got to produce the documents. But that's the primary obligation for at least what we tell our clients is, you're going to have to respond to us and give us the information we need to prepare the complaint. And then we're going to do the discovery stuff to get the documents we need from the brokerage firm. But when they come calling and asking for stuff, we're going to need you to answer the phone and get what we need. But again, no depositions, and it is limited discovery. It's not the same that you would see in court with interrogatories and all this expansive information that you would have to provide. It's fairly limited to just the documents that you have in your custody or control. So So that's the obligations. In terms of the process, generally, again, most of these cases do settle. I think the latest statistic was that 80% of FINRA arbitrations settle. So again, for the vast majority of at least our clients, if you bring a complaint, your obligations are going to be provide the documents, and assuming you fall into the category of a case that's settled, that might be it. And if you go to a hearing, then you obviously are going to need to be sworn in and answer questions about what happened and what your background is, etc. In terms of the hearing, it is not going to be in a court. So there's differences there too. It's typically going to be in a large conference room at the FINRA location closest to you. There's FINRA locations throughout the country in most major cities. So if you're in, Lakeland, Florida, you're probably closest to Orlando, and so you'll go to Orlando for a few days, and FINRA will select either a hotel or a conference center or wherever to have you sit there for the week, and you're going to have the three arbitrators at one side at the end of the table. You're on one side, and the other party and their lawyers is on the other. But beyond that, there are similarities to courtroom. Again, you're not in a courtroom, but you're going to be sworn in. You're going to have to testify. Your lawyer is going to ask you questions. Their lawyer is going to get to cross-examine you. So from that standpoint, in terms of what you've seen on TV or what your expectation of a hearing would be, even though it's arbitration, it does feel like a trial. It feels like a hearing, but without maybe some of the pomp and circumstance and some of the things that I think do intimidate people. I mean, there's not a judge there. There's not a jury. You're just sitting there in a conference room with your lawyer, arguing your case in front of these three arbitrators that are going to decide whether or not you're entitled to any kind of recovery. So that's sort of the expectations on a hearing. Arbitrators are an interesting lot. For FINRA arbitration, the only requirement is that you have 5 years work experience in any field and then go through the FINRA training program. So we tell clients that expect the arbitrators to be not unlike the composition of your neighbors. If you had to go pick 3 of your neighbors at random, that's sort of going to be the background of your panel. And so that what makes that interesting to me, at least, is you're not necessarily going to have lawyers on there. You're not necessarily going to have a judge or retired, admin judge or whatever. And yet they're empowered with making both legal conclusions and factual conclusions and a binding result that you have to live with. And this is part of the challenge for both sides, and part of the reason that cases settle is that because of that, you do see wild results where you scratch your head and you kind of wonder how they arrived at that conclusion, and it goes both directions. But again, you're basically just picking 3 people off the street, and they have their own external biases that they bring to the table that you don't really understand or know going into it, and you're stuck with their decision. And this is a critical fact that, again, applies to both sides. But arbitrators are empowered to make, again, legal and factual conclusions, and their decision is binding. You have agreed by bringing the claim through FINRA that you will deal with what their decision is, and it's incredibly difficult to vacate an arbitration award. There have been examples where one of the arbitrators fell asleep and a party moved to vacate based on they're clearly not paying attention to the proceedings, and the arbitration was upheld. So, short of, the few times where maybe you could prevail on vacature would be where an arbitrator didn't disclose an obvious conflict, like they, used to work with one of the opposing lawyers or whatever. So some obvious conflict where they should have told you that, and they are required to disclose certain items, and they didn't, and you find out after the fact. Then you might have a shot of vacating, but for the most part, if you lose, you lose. And there's very limited ability to appeal. And again, that's good and bad because it does cut both ways. And I'm sure defense lawyers who represent brokerage firms are giving their clients similar advice, saying, hey, whatever happens, happens. If we're ordered to pay an award, I would tell you that you've got a very limited ability to have that vacated, so you should pay. And so that goes back to, you have to live with that decision, but assuming you prevail, that it goes back to FINRA being quicker than court, because one of the things that can drag out court cases is the appeal process and the fact that can be taken and dragged out longer and longer. Generally speaking, in FINRA, You get an award, they pay 30 days later, move on. And so again, if you've tried the case within 12 to 15 months of filing, you get your award. A couple weeks later, they pay 30 days later. The time from when you brought the claim to when maybe you get some money is much less than it would be in court. In terms of, again, going back to client obligations, expectations, things that you would have to deal with, certainly there are costs involved. Again, this is one where FINRA is considerably less expensive than court, and it primarily has to do with those depositions, because when you remove depositions, you remove lawyers having to fly all over deposing people and incurring travel costs and, ordering transcripts and exhibit binders and all that good stuff that comes in play when you're having all those depositions. So that's the primary reason why arbitration would be less expensive. But you do have costs. You got to pay for the arbitrators to hear your case. That's generally incorporated in the FINRA filing fee, which ranges depending on the amount of the claim that you're bringing. But if you're suing for $1 million plus, I think the filing fee right now is $2,000. So not de minimis, but not, extraordinary either. And certainly there are other processes like AAA arbitration and JAMS where your costs are considerably higher than that. So in the grand scheme of things, that's fairly reasonable. We tell clients that's the only guaranteed cost, because you can't start your case without paying that filing fee. Everything else that comes up in the process really has to do with is the case going to hearing. So for a lot of clients, there are no other costs because 80% of the cases settle. But if you did go to a hearing, that's when you get into some additional expenses like, are we going to hire an expert? Does my lawyer need to travel? How many hearing days are we talking about? If you lose, you could potentially be on the hook for hearing costs. Although that's a pretty extraordinary remedy that to me at least suggests the arbitrator really didn't like your case and didn't think you should bring it. Excuse me, because typically those expenses are shared, but that's sort of your worst case scenario is you pay a filing fee, you take your shot, you lose, and now you're on the hook for, some travel and an expert, et cetera. So those are all things that should be considered when, if you're sitting at home going, man, I think I got taken advantage of, but I don't know if I really want to do anything about it because I think the process might be daunting or cost prohibitive, or, I'm not sure I'm even going to live that long. That's sort of a bullet point on expectations and how long does it take and what would you have to do and what would it cost. We're going to take a quick break, and then when we come back, I will talk to you generally about FINRA statistics, because again, I think that sort of plays in on, is it worth it? Should I do something?
Wish you had more time for fun in the sun with your family? Bogged down with that never-ending list? The shopping, chauffeuring, arranging, organizing, and don't forget the pet appointments. Maybe you have a birthday or anniversary plans to make. It's all so time-consuming. Let Lifestyle Concierge of Vero Beach help you get things done. We're that extra pair of hands you need to balance your day. We offer customized, affordable services to fit your needs. Call 772-217-2160 or visit us online at www.conciergevero.com. Lifestyle Concierge of Vero Beach, making life easier every day.
It's time to call Easy Brew Coffee and Bottled Water Service and learn just how much you can save and how convenient it is to have your coffee and bottled water delivered right to your home or office. In addition to water coolers, Easy Brew offers individual bottles of water in 8 or 16-ounce bottles. No more lugging it home or dragging it into the office. Serving the Treasure Coast for over 2 decades, 2 letters, 1 simple name, EZ for Easy Brew. Visit e-zbrew.com or call 800-792-3285. Easy Brew.
I know it doesn't feel like it, but would you believe 2016 is almost here? This means you have to get going and make your reservation to be in the definitive all-year-long Who's Who in Indian River County Chamber Directory and Tourism Guide. The Chamber Directory is mailed to all the Chamber members in January, goes to the hotels, medical waiting rooms, government offices, relocation packets, and more. The Tourism Guide goes to wedding shows and many out-of-state tourism shows. You do not want to be left out of these books. Call Idea Garden Advertising, 778-2832. Ask for Donna Roberts, and we'll take care of everything for you. We'll even hook you up to be on the Chamber website so people can click through to you and include your business on the Chamber newsletter with your own email blast, making sure the purchase of your ad is multimedia, web, print, and more. Make the reservation now, pay later. The important thing is don't be left out. Call 778-2832 or Idea Garden Studios. Together, we can make your register ring.
Welcome back, everybody. You're listening to Wall Street versus Main Street. I'm your host, Dax White. Today, we're talking about the FINRA arbitration process, reaching out to those people who maybe think they've been taken advantage of by their financial advisor and going through, a little bit of a blow-by-blow on what would the process be and what would be entailed if I decided I wanted to bring a complaint and try to recover some investment losses because I think I've been taken advantage of. So before the break, we talked about the arbitration process generally, how long it takes, what's involved for clients, what are some potential costs that they may have to worry about, because obviously those are important in deciding, do I want to do this? And now we're going to talk about sort of statistics, because obviously that would play into it too. I mean, if you thought it was going to take 12 to 15 months and you might spend, between $2,000 and $5,000, but you had a 0% chance of winning, you're not going to do it. So statistics certainly play into, is it worth it? The FINRA statistics are constantly changing, of course, but I think the last time that I saw published statistics, people were winning on average about 43% of the time. And so based a little less than a coin flip. And when they win, they are usually getting about half of what they're asking for. And so those may not sound like fantastic odds, not insurmountable, but again, I got about a 50-50 shot. Is it worth it to me? The one thing that colors that statistic, of course, though, is that 80% of the cases settle. And in my experience, if you're a brokerage firm and you're pretty sure you're going to lose, that's a case you're going to settle. So to me, the ones that get tried are ones where one or the other lawyers misevaluated their case, and you couldn't come to an agreement on whether or not to settle. And so now you're there trying the case, and the three arbitrators will tell you which one was wrong. But the most of the cases settle, and certainly, the very strong ones do. So if you remove the very strong cases, the vast majority of the very strong cases from the ones that get tried, that's going to impact your statistics. So that to me is sort of where that number comes out, is because you're in that 43%, you're seeing a lot of bad cases, ones where the brokerage firm said, let's take our shot on this one. We think we can win. Or you're seeing ones where maybe, one of the parties had unrealistic expectations. They were asking for far too much, and the brokerage firm said, there's no way we can settle this. But again, in my experience, if you're filing good cases, and this would be from the perspective of me as the securities lawyer who's evaluating these cases, my experience is you're filing good cases, and the brokerage firm, they know they're going to spend a bunch of money to try the case, and they're pretty sure they're going to lose. That's a case they're typically going to settle. So again, that should weigh in on your decision making, and that's something that frankly you should be talking to a lawyer about. If you think you have a case, talk to them about what are the strengths, weaknesses of my cases. What do you think our chances are? And if they're like me, they're going to spout off those statistics and say, well, there's your chances, because thousands of these cases get tried every year, and here's the statistics. But there might be a really good chance your case settles because we think yours is better than an average case. So if you're out there thinking, I lost some money in the last few years, and I think maybe I've been taken advantage of, should I talk to somebody? But you're on the fence because you just didn't know enough about the process. I hope that information helped to give you some idea of what's involved and what are your chances. Next week, we're going to talk about the top 8 things that the brokerage industry doesn't want you to know. I had set out to do 10, but I think 8 is scary enough as I put together the list. So tune in next week for that. If you want to send in questions for me, I'm happy to answer them. You can find us at wallstreetvmainstreet.com or at my law firm website, whitesecuritieslaw.com, and send a question to either of those, and I'll try to get to it in a future episode. You can also find us on Twitter and Facebook and LinkedIn and everywhere else. Thanks for joining us.
You've been listening to Wall Street versus Main Street. The views expressed by the participants of the program are their own and do not represent the views of, nor are they endorsed by, the White Law Group, its officers, directors, employees, agents, representatives, shareholders, nor any of its subsidiaries. None of the content should be considered legal advice. As always, consult a lawyer.